Hi, everybody. Thank you for joining us for this Lawyers for Learners webinar, Criminal Records, Background Checks, Expungements, and Pardons in Wisconsin. My name is Cassie Gunderson, and I am an intern with the Student Legal Aid Project at Legal Action of Wisconsin. Today, we're joined by two staff attorneys at Legal Action of Wisconsin, Evan McCarthy and Megan Sprecher. Thank you both for joining us today and sharing your expertise on these topics, and I will pass it off to you, Evan.
All right, thank you, Cassie. I'm ready for the next slide. So today's presentation is going to be on criminal record clearing, but first what I'd like to talk about a little bit is the consequences of criminal records. Besides the actual sentence itself, a criminal record or a criminal sentence can have what are called collateral consequences. And besides those legal consequences, there is also a stigma associated with having a record. In Wisconsin, kind of unique among Wisconsin's neighbors, especially in the Midwest, background checks are widely and cheaply available in many formats. That means that landlords, employers, nosy neighbors, people who have a name and date of birth and a little bit of money in some cases to spend can get a lot of information on someone. And that can create barriers for people who are looking for housing, people who are looking for employment, people who are trying to get a professional license or complete their education, and many more things. 1 in 4 people in Wisconsin, which is 1.4 million people, are estimated to have some kind of criminal record. And again, because it is so easily available in Wisconsin, that is 1 in 4 people who are potentially facing that stigma. The collateral consequences that I mentioned go beyond a fine or a jail sentence. They can have very long-term effects. Certain convictions can take away civil rights, like the right to vote or the right to own a firearm. And convictions can have additional requirements imposed on people, such as registering on some kind of list or checking in with a probation officer, all of these other things that can come with a criminal conviction. In Wisconsin, there are 2 main ways that people can look at criminal records. The 2 ways are CCAP and the CIB, and I'm going to talk about each of those in turn. Next slide. So CCAP is what most people call the circuit court records that are available online in Wisconsin. Many people in Wisconsin are familiar with CCAP because it is very easy to use and because it is all free and open to the public. Again, pretty unusually, it's especially in comparison to other states in the Midwest. But CCAP has a record of all circuit court cases, which includes all criminal cases. So any misdemeanor and felony in Wisconsin, if it's a state charge, is in one of the circuit courts in Wisconsin. It is available for free online, and you can search by a name and a date of birth and then find any case, including any civil cases or small claims or any other kind of thing that someone has been a party to. These cases will stay on CCAP until they age off or until they are sealed. And I'll talk a little bit more in a few minutes about what aging off CCAP means. Sealing is pretty difficult, is the main consideration to have in mind when you're thinking about sealing in Wisconsin, especially for criminal cases. But there are some limited options and situations in which cases can be sealed. Like I said before, CCAP is very, very commonly used. There's no barrier to access it. So regular people can use it, landlords can use it, employers can use it, schools use it. And it is one of the main ways in which information on a criminal record or information on even cases in some situations where charges were dropped or dismissed can still live on in the public eye. Next slide. So by default, cases will remain on CCAP for a certain period of time. And these times here in the little chart that we've got on this slide are set by statute. So these are laws in Wisconsin just governing the periods of time for which cases will appear on CCAP. So we can see here that felony cases, if someone is convicted, depending on the severity of the felony, the case will appear in the public record for either 50 or 75 years from the date of disposition. So that's the sentencing date. If someone is convicted of a misdemeanor, the default is that that misdemeanor record will stay for 20 years from the date of disposition. For forfeitures, which are traffic tickets or other non-criminal violations that have made their way into circuit court, one of the big ones would be if someone gets a speeding ticket, for example, from a sheriff, as opposed to a city or a municipal police department. Because it's the sheriff, because it's the county's jurisdiction, it goes to the county court, which means that a traffic ticket from the sheriff and from the county stays on CCAP. those stay for 5 years from the date of disposition. And I mentioned before, even cases where all of the charges were dropped, or if someone was found not guilty, the case will still appear on CCAP with just a record that will show that all the charges were dropped or that someone was found not guilty for 2 years from the date of dismissal or acquittal. Another reason that cases can stay on CCAP past these statutorily defined periods is if there is any outstanding fine. So if there is a misdemeanor, say if someone had a misdemeanor where they were convicted in 2000 and it's today, it's 2023, and they still owe even as little as just $5 or any amount on that fine, that case will stay on the public record. It will stay on CCAP and people will be able to see it and find it until that fine is paid off. So that is a consideration that people can take if there are older cases, especially some of these speeding tickets or misdemeanors. If there are outstanding fines, it can help things fall off a little bit quicker. But the 20 to 75-year range for criminal convictions is a pretty hard barrier to get around. Next slide. The other main background check that people work with in Wisconsin is from the Wisconsin Crime Information Bureau. The Crime Information Bureau is a branch of the Department of Justice. It compiles all arrests in Wisconsin where someone was fingerprinted. So when the CIB is compiling these arrests, it gathers what DAs say, what police departments say, and it just automatically puts them into a big background check document and doesn't necessarily contemplate what happened as a result of those arrests. So it compiles situations where people were arrested but charges were dropped, or they were never referred to the court, or where all of the charges they were acquitted on. And it also includes arrests for non-criminal violations. So if it's that situation where a township or a municipal police department does arrest someone and fingerprints them and logs it with the Department of Justice, even if they weren't actually charged with a crime and they were just charged with an ordinance violation or something similar, that still appears on this CIB report. And that by itself can create some kind of prejudicial inferences from people who are reading these documents. CIB reports are very easy to access. If you've got $7 and a name and a date of birth, you can pull a CIB record for anyone in the state of Wisconsin. So this is, again, it's something that landlords and employers and schools all use. In 2017, almost 1,900,000 CIB reports were processed in just that year alone. And that's close to the 1 in 4 number of people in Wisconsin. So this is something that people certainly know about, and it's also very, very readily available. But the difference between the CCAP report and the CIB report, the big difference on the CIB report is that this includes all arrests, even ones that wouldn't appear on CCAP can sometimes appear on the CIB. Next slide. CIB reports are not always accurate because they are just automatically compiled by what police departments and DAs and other law enforcement and courts enter into their databases. Until someone points out a mistake and until someone says that something needs to be corrected or changed or that the entire wrong name is associated with some arrest record, that they don't go through and proactively check. So this is something that it can be very harmful if records are commingled, for example, or if people with very similar names or similar dates of birth, or people who have used another person's name as an alias when they're arrested. Sometimes that can cause the uninvolved person's record to be mixed up with someone entirely different. And that's something that there are processes to correct these kinds of mistakes, but like I said, it is something that has to be proactively requested. Records also don't show necessarily what actually happened with a case. If a charge was dismissed or dropped, that isn't always reflected in the CIB report. If a charge led to conviction or a deferred prosecution agreement or any other kind of outcome, that also is not necessarily reflected in the CIB report. So there are ways to ask that they update the disposition to include things that fell through the cracks or were never registered with the Department of Justice. But there are situations that we see sometimes where cases are listed as being unresolved that can look really bad, and it's better or in someone's interest to have a resolution to show that they were found not guilty, for example, of a worse charge, as opposed to just have things sort of dangling as far as anyone reading this report would be able to know. Next slide. So there are a few options for clearing records in Wisconsin, clearing and correcting records. The general rule is that it is not possible to remove conviction records from public view before the age-off period in CCAP. The sealing option that I mentioned is very, very limited, and it's related to, oh, my apologies, the light went off in my room. Okay. The sealing option that I mentioned for CCAP cases is very, very limited. It's related to a process called expungement that Megan is going to talk about in just a few minutes. But the general rule is that that is very, very hard to get. Arrests reported on a CIB report, the report that's compiled by the Department of Justice, can be removed if the arrest didn't lead to any conviction. So if someone is arrested and charged with 10 things and 9 of them are dismissed, but 1 is a conviction, unfortunately, that means that those records can't be removed. But if all of the charges associated with an arrest are dismissed or someone is found not guilty, then those can be taken off of the CIB report. I just highlighted expungement a little bit, but we're going to hear more about that in a little bit more detail in just a second. But the final option for trying to clear or clear up a record in Wisconsin is pardon. A pardon is an option that people who have a felony conviction in Wisconsin can ask for. It is a grant of forgiveness from the governor, and Megan's going to talk about that in just a minute too. But importantly, a pardoned case does not remove the conviction from CCAP. It does not remove the conviction from the CIB. It doesn't seal it. It still remains in public view, but it can undo and remedy some of those collateral consequences that I talked about. All right, with that, I am going to hand it off to Megan.
Thanks, Evan. So I'm Megan Sprecher. I'm an attorney with Legal Action, and I'll be doing the latter half of the presentation. So Evan talked a little bit about the different options that people have for removing arrest and conviction records. So the form that you see in this picture is the form that the state, that the CIB department of the Department of Justice requires that we use to ask that an arrest cycle be removed from a background check. So again, if any of the charges or sequences on an arrest cycle did not result in a conviction. So if all of the charges or sequences were dismissed, not charged, acquitted, then we can ask that that cycle be removed from the background check. And this is the form that we do. So we list the arrest information on the form, the arresting agency, the date, the charges, the disposition, and then it does require fingerprints. So index fingerprints on this form. Those are things that we can do. We can do the index fingerprints for this form through our partnership with Lawyers for Learners. There is no fee. There's no court filing. This is an administrative process, and we submit the form to the Crime Information Bureau. Once the CIB processes it, what they do is they look into it. They double check that the arrest cycle did not result in a conviction. They also compare the prints on the form that we submit to the prints that they have on file for the arrest record. And once they confirm that it did not result in a conviction and that the prints match, then they will remove it from the background check. They will also notify the arresting agency and instruct them to destroy the fingerprint records as well. What we find, it does vary, but what we find is that it generally takes about 6 to 8 weeks to get a response on these requests. Next slide. So for correcting arrest records, Evan talked a little bit about correcting arrest records. So sometimes, we're not able to remove the arrest cycle, but there are corrections that we can ask be made so that it's in the client's best interest. So an example of that would be the CIB shows that something was a felony conviction and it was actually a misdemeanor conviction, or the CIB shows that there was a dangerous weapon modifier, but it actually ended up getting amended so we could show that wasn't part of the ultimate conviction. Another reason that we would do a request to correct a record is in the case of identity theft. So we will often pull a client's CIB, and at our larger clinics where we register 36 people, we generally see 1 or 2 CIBs that do involve identity theft. So it would be like a person has arrest cycles on their background check that are not them. So often this is, a sister, a brother, a cousin, someone giving a different name when they're stopped by the police. And what that can result in is additional cycles or even kind of like another CIB after our clients. And so what we do is we fill out a criminal history challenge form for any of these correction requests. And in the case of an identity theft correction, the person has to go get a full set of fingerprints through law enforcement. And then what we do is we submit that with the criminal history challenge form, and then CIB compares the prints on the full set of fingerprints with what they have on file, and then they will remove any of the cycles that are not our client and put a flag on the CIB that there has been identity theft. Next slide. So expungement, Evan alluded to this previously, is pretty limited in the state of Wisconsin. Our expungement law is quite narrow compared to some other states. So to qualify for expungement under our current statute, the person has to be under age 25 at the time of the incident. Depending on what expungement statute was in place at the time of the conviction, it could be that the person had to be under age 21 at the time of the incident. The judge has to have ordered expungement at the time of sentencing, which is quite unusual. So in most states for expungement, you're convicted, and then a couple of years later you go back and you show the judge why you deserve an expungement. I got my GED, I have a good work history, et cetera, et cetera. And the judge makes a decision on expungement at that time. In Wisconsin, our statute requires that the judge actually order it at the time of sentencing. And so that makes things a little bit more complicated and can make it more difficult to get an expungement. The person has to have fulfilled all requirements that the judge ordered and that the Department of Corrections ordered. If all of the above requirements are met, then the person can ask the court to expunge the case. If it is successfully expunged, what that means is the case comes off CCAP, the court records are sealed. It still is a conviction. So that's something that I think is really confusing oftentimes for our clients. It is still a conviction and the case remains on the CIB. So the Department of Justice's perspective is that, the court records are sealed, but it doesn't mean that CIB has to seal the records. So the arrest cycle remains on the CIB and then is updated to reflect that the case was expunged. And then other records, like with the district attorney's office or police records, they are not required to seal them as, if a case is expunged. So they follow their own policies and protocols about that. So, that being said, it is very beneficial for our clients, just to have it come off CCAP, because that's such a common place for potential employers and potential landlords to look up. And so it is, definitely beneficial for our clients if they are expungement eligible. But again, the narrow nature of the statute makes it not accessible for many people. Next slide. Pardon. So Evan talked a little bit about pardons. Pardon is a grant of forgiveness from the governor. And what it can help with is restoring civil rights lost as the result of a felony conviction. So one thing that I do want to clarify is that in Wisconsin, unlike many other states, people who have a felony conviction are able to vote again once they've completed their sentence. So there are some states where if you have a felony conviction, you lose your right to vote and have to petition to get it back, or maybe just can't get it back. In Wisconsin, you do get your right to vote back as soon as you complete your sentence, but that's not the case in other states. We see a lot of our tech college students, need a pardon to be able to get a certain professional license. It's also just helpful in general in terms of obtaining employment and access to rental housing. Whoever's the governor at a particular time gets to decide what the criteria is for a pardon. So some governors decide not to grant pardons at all. Some decide to have a pardon board. So under the current system, under Governor Evers, he has a pardon board that sort of vets cases. And the baseline criteria to be able to apply is that the person is seeking a pardon for a felony conviction. So at this time, they're not considering misdemeanors unless they were sentenced at the same time as a felony. The person has to have finished any sentence, any criminal sentence for any case, including probation, including jail or prison time, at least 5 years ago. They cannot have any pending criminal cases or charges, and they're not currently required to register as a sex offender. So that's the baseline criteria. The board certainly looks at a variety of factors when making a recommendation to Governor Evers, and then he has the final decision. If the pardon is granted, like with an expungement, it is still considered a conviction, and it does stay on CCAP, unlike with an expungement, but both CCAP and the CIB are updated to show that the pardon was granted. Next slide. So the pardon application is available for free online. There's no cost to file. There is a requirement that the person submit certified court records for the case that they're asking be pardoned, which requires payment and can be done through the clerk of courts. A pardon is a process where you're essentially asking for forgiveness. So it's something where the person is taking responsibility for the conviction and then talks about their personal growth, their community involvement, and any positive factor helps. This is where our tech college faculty and staff can really be helpful because, a letter from an instructor saying that the person is working on their GED or is in the human services program or, is on student senate or whatever may be, it can be really persuasive to the pardon board to show that the person has changed their path and is on a upward trajectory. Right now, it's taking about 18 months once a person applies until they get their hearing. So it is a process that, does take a while. But like I said previously, it is up to the governor at the time if they're going to grant pardons or not. And there have been, administrations that just don't do pardons. So something to really keep in mind that Governor Evers is, really committed to the pardon process. Next slide. So some resources for clearing records. Our project, Lawyers for Learners, can assist people through our virtual clinics about background check issues, expungement, pardons, corrections. So we have regular clinics where people can meet with one of our pro bono attorneys to go over their background check, flag any cycles that can be removed, corrected, pardoned, expunged. And then what we do is we do the follow-up work internally at Legal Action with our wonderful interns, or we place cases with our equally wonderful pro bono attorneys. The forms are available online. I will note that the Wisconsin pardon application is going to change in the new year. The board is hopeful that it'll come out in January or so. There will be about a 2-month grace period where we can still use the old form, but just to keep in mind.
Our contact information, both Megan's and my own, it's here on this slide. We're happy to field any questions, but like Megan said, if there are specific concerns about a background check, or if that's someone, or if you know someone who needs a little bit of assistance, the Lawyers for Learners form is the best bet to get in touch with not just Legal Action, but also a lot of other legal service providers who can help with different issues as well.